Well, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome to this episode my guest, Robin Ross. And Robin is a partner in the firm of Ross and Calandrillo with an office in Mountainside, New Jersey. And her practice is dedicated to family law. Robin is a certified matrimonial attorney, and she's also the current chair of the solo and small firm section of the New Jersey Bar Association. Well, welcome to Law on the Line.
Thank you so much for having me.
And we have an interesting topic today, and it's a little bit unusual, and it's going to be, and it is, cannabis and custody. And Robin is an expert in the area of the law, not necessarily in cannabis per se, but but in the law and how the legalization of marijuana has affected and changed the perception of marijuana vis-a-vis custody.
Right.
So anyway, welcome aboard.
Thank you.
And I know you made it easy for me, Robin. You gave me a series of excellent questions. And as I mentioned to you in our preliminary discussion, cannabis and custody were polar opposites. One would never be considered a part of the custody equation. It would be losing custody.
Oh, absolutely.
So the question is, how has legalization of marijuana affected legal custody battles involving parents who use marijuana?
So I'm going to give a very lawyerly answer. A lot and not at all at the same time. So just like you said, when I first started practicing more years ago than I'd like to talk about, when I was
less than me.
When I was 4 years old, when I started practicing law, it was just as you said. If someone was accused of using marijuana, I remember being in a courtroom with a client. Other party accuses my client of using marijuana, and the judge sends him out to take a urine test then and there. And if that test comes back positive, I can rest assured that my client is losing custody, or at the very least, there's going to be some suspension of the custody and parenting time until that issue is cleared up.
I remember many times of
course,
the urine tests, and again, judges just barring custody until there was a real clarification of whether or not there was use or misuse, misuse of marijuana.
Right, anyway. So it was on the same line, right? So it was marijuana was exactly the same as testing positive for heroin. Exactly the same.
Correct.
Then that started to change even prior to decriminalization. So that didn't happen until 2021. But keep in mind that medical marijuana use was then made legal in 2010. So it took 11 years before the recreational use was now, legalized as well. But I could start to see the sea change in how judges were looking at marijuana use and custody and parenting time even before the legalization. So the reason I say a lot and not at all is because I can recall very vividly having conversations with judges and saying, well, we think that there may be some marijuana use. And I remember, I won't say which judge it was, but the judge going, and? So what? And this was before 2021, before legalization. So I think that really what happened is that the law finally caught up with with societal beliefs on marijuana, that it really wasn't the same as some other drugs. And judges weren't necessarily taking it as seriously as far as just per se taking away custody and parenting time. So case law at this particular time is still pretty sparse. So that's why I say, how has it changed? Not a lot, because even as far back as 2017, most of the case law deals with DCPP cases. So,
and what is DCPP?
So that is the Division of Child Protection and Permanency. Back in my day, we called it DIFUS. Okay,
right.
So I still call it DIFUS. I may use them interchangeably, so forgive me if I do. But most of those are surrounding DCPP cases where there's an allegation of marijuana use and what impact that may have on the action that DCPP can take as far as taking custody, custody and supervision, or care and custody of a child under either Title IX or Title 13.
Right. So Title 30, right?
30, yeah. Excuse me.
And in this regard, how do courts assess a parent's marijuana use when making decisions about child custody and visitation rights in 2023, as in contrast to 10 years ago?
Yeah, so what I think that they're doing is the best thing that I can tell both, colleagues that practice with me and my clients that are dealing with these issues, is that courts are really looking at it very similar to alcohol use, right? Alcohol is legal, but that doesn't mean that it can't be abused. That doesn't mean that it can't be used in such a way that it might be contrary to the best interest of a child, or it may put a child at risk. Safety of the child may be at risk. So the way that courts are assessing it, and I think that I can get on a little bit of a soapbox about this, so you can tell me to get off my soapbox if you need me to. But I think that what's really important right now is that courts are really relying very heavily on the crutch of using experts to try to figure out whether or not the use of marijuana rises to the level that this is putting a child in danger. And the reason I soapbox on this a little bit is because if I have clients that are coming in and, retaining an attorney in private practice, usually that client can afford an expert. Experts are very expensive. The reason I think that it starts to form a bit of a socioeconomic divide is that if you have a client that cannot afford to retain an expert to opine as to whether his or her use of marijuana rises to the level that it endangers the welfare of that child, that parent could very easily lose that case because the judge is saying, who's to tell me whether or not your use rises to the level or not? So, number one, I think without an expert, a judge would probably have to look at whether or not it would fall into the category of cannabis use disorder. They look at the DSM-5 and say, is this some sort of mental impairment? For
our audience, DSM stands for the
diagnostic something manual.
Okay.
Something is not the S, but
right.
I don't remember what the S stands
for. And okay, so I just want to build on that. Mm-hmm. How does this issue of marijuana use, generally speaking, get before a judge? An allegation is made by a parent that the other is...
Absolutely. 9 times out of 10, when you're dealing with this issue, in a custody and parenting time, I would say non-DCPP area. If you're looking in just a straight, family law, maybe a, matrimonial or even a non-dissolution sort of litigation.
A non-divorce.
Yes, non-divorce. It's typically either the other parent that's making the allegation to say, wait a minute, I think that my child is not going to be safe in the custody of mom or in the custody of dad because of his or her marijuana use. Now, one of the issues that come up with that, of course, is, well, why was the child safe while you were together? You knew of this use, right? I mean, typically this is not something new that has come up after, the relationship is broken down or after, the parties have separated.
So while intact, it was tolerable.
All good, right?
Yes.
It was all fine. So, judges are asking that question of what is different now. So the one thing that may come up in that context is, well, what's different is that I, as parent number 2, I'm not there to monitor. I'm not there to help. I'm not there to be there for the child when, the offending parent is high and unable to parent the children effectively. But I think that what courts are really looking for, aside from an expert, is they need actual concrete behavior. The use of marijuana in and of itself is not going to be enough. It's not going to be enough in a family law context, whether it's a divorce litigation, whether it's a non-divorce litigation. It's not going to be enough even in a DCPP litigation. There has to be attendant behavior with that marijuana use to let the court know that there's something mom or dad is doing.
Or not doing, as the case may be.
Or not doing, right. So, some examples that I give. If, you're so focused on your marijuana use that you're forgetting to pick up the child from school, that you're forgetting to bathe or clothe the child, or engaged in other neglectful behavior because you are so focused on the use of marijuana, which is one of the symptoms. If you look at cannabis, use disorder under the DSM, is that you are so focused on the use that you're, not going to work, you're not taking care of your family, you're not attending to your responsibilities. Those are the things that a court's going to be interested in more so than just the per se use of marijuana. That positive test is not enough anymore.
So under those kinds of circumstances where there is enough testimonial proof that a person is neglecting his or her responsibilities, do you need an expert in those kinds of cases? If there is an admission, I mean, a party could deny, I don't use marijuana, I don't know what she or he is talking about, but let's assume there's an admission, yes, I use marijuana, and yeah, but I deny all the allegations about neglect. What kind of proof would a litigant who's proposing that the person is unfit needs to establish before the court?
So the person proposing that the other parent is unfit would have to provide, in my mind, some sort of neutral or third-party proof that this is actually happening. I would ask for school records, whether there are drop-offs or pickups that are not occurring as far as attendance is concerned. I would probably get the children's doctors, pediatricians, if the child is in therapy. And in 2023, 9 times out of 10, the children are in therapy when they're going through some sort of divorce litigation. And if that child is reporting some sort of impact, whether it's, when I'm at mom or dad's house, they're not present, they're off doing something else. If, child is old enough to actually articulate what's happening, sometimes if there's a teenager, child might be old enough to articulate, I'm smelling the marijuana. I know that that's what's going on. If the child is younger and can't articulate that, it may be the use of some sort of third-party system to basically corroborate what the accusing parent is saying. Interesting thing about age is that if you're looking at the case law, though, is that if you have an older child, a teenager, 13, 14, 15, who may be able to articulate that these things are happening within the home, mom or dad doesn't help me with homework, mom or dad forgot to pick me up from school, mom or dad is, they're out smoking marijuana all day and I'm not doing anything with them. It's kind of interesting because a court would look at the fact that the child is old enough as kind of grounds to say, well, maybe we're not going to take away custody and parenting time because you have a 13 or 14-year-old who's fairly self-sufficient, and if mom and dad's not helping with homework, that's okay. They're actually going to look more favorably on that older child than an infant who is not able to report what's happening, not able to care for his or herself, not able to feed, bathe, and clothe his or herself. So those are some of the things that you may want to present to a judge if you are the parent accusing that the marijuana use is negatively impacting another parent's ability to parent.
You mentioned something about, medical doctor's records. And maybe there is a reference that a child maybe mentions and it shows up in the notes that, my parent or a parent smokes pot in the house. Or how does that get into evidence? Or how does a judge see that record if you don't have the doctor as a witness, because it's generally speaking impossible to bring a doctor in?
You usually can't. I have not, in my years of practice, on I think only one occasion, had a doctor who said, I'll come in and testify as to these records to get them in. Usually, if that is the case, you can reference them within a certification. Unfortunately, we as family attorneys know that our certifications to the court from clients are typically rife with hearsay. So, it's not abnormal to have your client say, this is what I was told by the doctor. But usually that's, again, where an expert's going to have to come into play, because if you get an expert to come in to do a best interest evaluation, even if it's a brief focused evaluation only on the issue of that substance abuse and the impact on custody and parenting time, then that expert may be able to speak to that physician as a collateral source to try to figure out what was being told or what the doctor knows and put into his or her record that might be relevant for a court to know.
Now, you said something about best interest investigations. At one point in time, just a few years back, they were very commonly used by the family court. I find today that because of lack of resources, best interest investigations conducted by the court through the probation department just are not being ordered.
No.
And but in the rare instance that there is a best interest investigation, how have you seen the personnel of the probation departments who conduct them react to an allegation of overuse, let's call it abuse of marijuana?
I don't think that their reaction, in my experience, has really been as serious as private best interest experts. So when you get an expert that you're actually paying usually a pretty hefty rate, probation, I don't think that they're reacting as seriously. I don't think they really take the marijuana use as seriously. And it could be that they don't have the requisite training in substance abuse to try to figure out whether or not this will actually rise to the level of being something to be worrisome. So, I think they're very used to alcohol. They're very used to dealing with, use or overuse of alcohol. But the problem with marijuana use is that you don't have the same ability to test for it
Correct.
that you do for alcohol. So while, these evaluations going through probation may be, well, prior to your parenting time occurring, you need to test for alcohol. We all know, systems like SoberLink or things like that,
yes.
that you can use prior to parenting time occurring to make sure that you have not consumed alcohol prior to that parenting time. That may be something that within a best interest evaluation ordered through the court, that, if there's an allegation of alcohol use, that the evaluator may say, well, we're going to do some testing, or we're going to require that some testing occur to make sure that it's safe for the parenting time. Can't do that with marijuana. There's really no test that's akin to SoberLink or something along those lines to test whether or not that parent is under the influence currently. I think that they're working on some technology to see whether or not that's something that we can do, similar to maybe a breathalyzer or something along those lines.
And we don't have a drug recognition officer who's standing by, so to speak, right?
We don't, right? And then if you're doing additional testing, or if additional testing is ordered, whether it's urinalysis or a hair follicle test, the look back of those
Yes.
tests are so far
Right.
that, I, as a parent, could have legally consumed marijuana at a party a month ago when I didn't have my children with me. Maybe it was the other parent's parenting time. And that doesn't mean I'm going to, that test is going to come out favorable a month later. So we can't really use that,
That's
right?
true.
That's not really reliable.
When you mentioned experts, now, if I am making the allegation that the other side, my former partner, abuses marijuana, and that abuse occurs while that parent has custody or is exercising custody of our children. The expert that I hire to establish that allegation, and work off the underlying assertion that I've made, is that person a neutral person, or is that a hired gun? What are the duties of that person, the expert, to make an objective finding and recommendation to the court?
So I think that there is, especially in the non-legal world, there is a perception of experts as hired guns that I think
Correct.
that we as practitioners no, it's not always the case. Experts do have a duty, whether it is a individual expert that you have hired on your own, whether it's a court-appointed expert or whether it's a joint expert, to actually accurately report to the court his or her findings as to whether or not that use would rise to the level of being harmful to the child or would not be in the child's best interest. I don't think, and I know when I first started practicing, I used to think that there were all these hired guns, but I've learned in my years of practice that, experts are actually very, very ethical people. And what they may do is not render a report if they are, an individually hired expert, but they may have a conference call with the attorney or give them some notes that might fall under attorney work product, depending on how that engagement letter was signed, that says, I'm finding that there is a problem here, and that's what I'm going to have to report to the court. I think where we may fall into a little bit of a black hole is that experts are just now, with the decriminalization of marijuana, kind of getting up to speed as far as their own training to become, I don't want to say good enough, but have the expertise that the court's looking for to actually make an opinion as to whether or not use of marijuana would rise to the level of being something that's problematic. So I think that where we're falling into a little bit of a problem is that experts are getting up to speed on this issue, but there aren't that many experts that really have the qualifications. I've spoken to some, candidly and said, look, do you think that you're qualified to deal with this issue of marijuana use and whether it rises to the level of being problematic for the safety of a child? And I've had experts that have said to me point blank, no. Not yet. I'm not trained in that. So you really need to find an expert that's trained in substance abuse disorders, and you need to make sure that you're hiring appropriately so that you're actually getting somebody that can give the court the information that they need.
So if the use of marijuana is only established by observation and the testimony of one party against the other, and perhaps that party has, for example, a parent who maybe participates in some of the parenting time and makes observations, or a 14 or 13-year-old child who can testify or at least report to the court, and we'll get to that in a minute, about, when I'm over at dad's house or mom's house, and they're lighting up and smoking pot and quite frankly laying down on the couch and not paying any attention to me, but more particularly to my younger sibling.
Yeah.
How is that testimony available to the judge? And what about bringing in children to testify in open court or in camera? What's your experience in that?
So what I would think is, how is that testimony getting brought to the court? So usually it would have to be one party requesting, if there is a child, for example, that can speak to what impact that marijuana use is having on the parenting time, which is really what's important, because the marijuana use in and of itself, even if mom or dad comes in and goes, yeah, you're right, I'm absolutely smoking marijuana, there still needs to be that next step of what impact does that use have on his or her ability to parent the child. So I have not seen, other than one time in my career, a judge bring in a child to actually testify in open court. As far as one time it happened, and I was actually floored by it. But usually the testimony or the interview is going to be in camera.
Right, in camera. Meaning
that the judge is going to bring the child into chambers. It's not going to be in a courtroom, and it's going to be, an interview just between the judge and the child. Typically, attorneys can provide some questions to the judge that they may want, the judge to ask to the child. But it would be an interview, in chambers with the judge and a child. And what the judge would really want to elicit from that child is not so much, is mom or dad smoking marijuana or edibles, which, taking edibles is actually on the rise and happening more often than the actual
vaping
smoking
or
vaping, right? That's happening more often. But the judge is not going to necessarily ask, try to get the aha, is mom or dad actually, engaged in marijuana use? But the questions are going to really be more focused on, well, when mom or dad smokes, well, then what happens? What are you doing? Is mom or dad available to give you dinner? Are you cooking dinner by yourself? Are they available to take you to school? They may ask how the child, feels about, what is happening or the marijuana use, depending on the age of the child, right? But what the judge is really trying to get to the heart of is, again, what impact is that use having on this child? What impact is that having on that parent's ability to appropriately parent that child and provide a safe environment for the child? But what I would say is that even with an older child, 14, 15, 16 years old, I do not think, and this is just based upon, my experience, what I've seen and what judges may speak to, I do not see a judge making a decision and having that decision rise or fall on the testimony of that child. So I think especially now that the marijuana is legalized, once again, you're going to need a lot more. It's akin, and I've said this to clients, it's akin to saying, well, when I'm home, mom or dad drinks a glass of wine in front of me. So what? It has to be, is mom or dad falling asleep? Are they stumbling? Are they slurring? I think what I would kind of call the piece de resistance, right? Is mom or dad getting in the car with you after that? Because even if it's one puff of marijuana or one edible, and then they're saying, okay, I'll drive you to soccer practice, the judge is going to find that behavior to be problematic and also falling under a symptom within the DSM of cannabis use disorder.
And it could be revealing of other character traits of that parent, and it may not necessarily be the marijuana alone. It may be a crutch or a device that this parent uses, but the parent is otherwise neglectful in so many other ways. So it's a number of factors as to how that would impact custody. So you raise an interesting point when you say, what role do parenting plans and agreements play in addressing marijuana use by parents, and how are these agreements structured to ensure the best interests? So very quickly, an agreement would be a marital settlement agreement or a separation agreement if the parties are not married.
Correct.
So how would that, in your practice, address a concern that the parties have and they want to memorialize that in an agreement?
So it could be addressed in a couple of ways. One, if you have an agreement where one party believes that there's a problem and another party believes that there is not a problem.
Right.
Sometimes we can put language into the agreement to simply acknowledge that the parties don't agree as to whether there's an issue. So I've drafted language to say, well, there have been allegations made of marijuana use that impacts mom or dad's ability to parent. Mom or dad denies that there is marijuana use impacting the ability to parent. However, the parties understand that should this become an issue in the future, that it would rise to the level of such a change in circumstances that this could go back to court for custody and parenting time review. I know, I'm sure you say to your clients, I say to my clients as well, custody and parenting time is always modifiable, right? So it's not something set in stone. But I've also had agreements where if there has been an acknowledgement of marijuana use, that you've had one parent that's either agreed to undergo some level of testing, some level of therapy to deal with the marijuana use and whether or not he or she is using that particular substance as a crutch. I know recently in the news, I think I read in the New York Post, which is excellent and very detailed reporting in the New York Post, right? Like that's quite the source.
But we're running out of time. I just want to let you know we got about 30 seconds left.
About the star of the Bear, that show, I think his name is Jeremy Allen White or something along those lines. But he put into his agreement, it was about alcohol use, but testing, that they were agreeing to things like that. So that can go into an agreement
and parties could agree that they will not smoke pot or drink in the presence of the children,
around the children, right?
When they're acting as primary parent.
But how do you enforce that?
That's true. Just one anecdote, real quickly, so we don't have any time left. What you have a particular anecdote about where legalized marijuana has played a significant role in determining child custody arrangements?
I mean, I would have to say with marijuana use, it really has been where one parent admitted to the marijuana use, admitted to actually, agreeing to take testing, and actually agreeing that parenting time within that agreement would either be supervised to a certain level, and that's a huge impact if you have supervised parenting time simply because of marijuana use. But there's really only been that one time that it had that significant of an impact on custody and parenting time without there being some other attendant behavior behind it.
Okay, so I guess the bottom line is that other attendant behavior.
Necessary.
And the 30 minutes have come and gone. And I thank you so much for I think a very edifying program for our audience, and the new with legalization and how it does affect or impact all aspects of lives as it relates to children.
Thank you so much for having me.
You're very welcome. Thank you for being our guest.